So I spoke with another one of our Jasmines last night, Ms. Willingham. She says hi to everyone. She misses you all a lot. It's a strange time to be working for the federal government. Although she observes she is in one corner of the federal arena that will likely be protected under this administration. But she's missing you all. Apparently, Mr. Peoples is coming back.
I was wondering.
Already. They have to wait a little bit because of, I don't know why, but he'll be back sort of mid-year. And I think Ms. Willingham is wrestling with similar thoughts. But in the meantime, we've got a great Jasmine here handling business. And we have a final plea calendar. I'm guessing most folks are in custody because we don't have a lot of people in court. And then I was told that the suppression hearing we were going to have this afternoon will actually be a plea this morning.
Yes, sir.
Okay. Well, let's just get through the calendar. We don't need to bring folks out initially. If you can just let me know what the plan is, then we can bring them out to do what we need to do. Brian Henley.
He's mine, Judge. I think he's on Zoom.
We do have a cell phone, a Motorola phone, and Mr. Lim or Ms. Lim, but that's it. So maybe he's the Motorola. There he is. Oh, I know this guy. Like, I thought I recognized the name. I definitely recognized the face. All right. So Mr. Henley is here. What are we doing with Mr. Henley today?
Final plea hearing, Judge.
Final plea hearing. All right. We will do that in a minute, Mr. Henley. Sit tight, and we will circle back with you.
Yes, sir.
All right. Christopher Shanks.
Yes, Your Honor. Mr. Patrick had to go to Kraus to handle something and he was going to come back. We're trying to figure out the situation here. We had an agreement to accuse some of the unindicted cases. He has like 2 or 3. It's very confusing. He has some like maybe 4. Some are DWAP, some are not. We're trying to figure out so we can do a global resolution. We've already agreed on a global resolution. He was trying to be accused, but then he said, I have to do a waiver first before he can accuse.
Okay.
And so I was trying to do the waiver, but as I'm looking through all the cases, I'm trying to figure out which ones I need to do the waiver on. And then he said he's going to come back and we're going to talk about it.
Okay.
And he has probation.
Okay. I thought Mr. Patrick wasn't coming to this courtroom and that someone else was, but I guess that's changed again.
That's who I've been talking to
The
about
last
this case.
that I heard was Mr. Patrick.
Okay, I'm good with that. Someone had told me that it wasn't going to be, and I'm not remembering. Oh, that Miss Charles was coming back here. That's what we had been told. Guess that didn't happen. Well, all right. So Mr. Patrick will be back in here today,
Yes,
this morning, and then we can work through. If you just need to do a waiver on all of them, just to make it easier, we can do that. So we'll bring Mr. Shanks out and talk, but he understands that there may not be closure today.
Well, we thought it was until the hiccup this morning when he said, because Mr. Patrick said he was going to get indicted this morning, and then he texted me this morning and said, I need to do waivers, so.
Okay, well, we'll get Mr. Patrick on the record committing to something
Okay.
with these other cases when he comes back. All right, Mr. Lim is on the Zoom.
Yes.
What are we doing with that?
This will be a plea. I just need to speak with the state briefly and then I need to call Mr. Lim. So, well, speak you want, but it'll be a plea today.
Okay, great. No interpreter needed?
No.
All right. Mr. Perry is represented, how are you, sir? By Ms. Gladden. And she very, very belatedly filed her entry of appearance, but she's filed her entry of appearance. Yes, sir, Mr. Perry.
All I know is that I did talk to her, she said that she was coming up with bed. She said she's been another court on downstairs.
Ms. Gladden, no, she'll be here today. Yeah, we just, as of last night, I couldn't figure out who your lawyer was. But it turns out it is Ms. Gladden, and she did file an entry, which is what she needed to do. So you can just sit tight till she gets here. I'll need you to stay here until Ms. Gladden gets here. And you have a co-defendant, and that's Ms. Hightower, and you're represented by Ms. Taylor. Okay, what'd you hear from her? When's she gonna be here?
She's on Zoom because she got 8 other cases, and she's gonna be here at 10.
She'll be on Zoom at 10.
No, she's on Zoom right now, but she'll be here by 10.
Okay, she's not on Zoom right now, but if she's gonna be here by 10, then we'll see her at 10. Great. Mr. Haynes, he represents the bulk of this calendar.
Yes, Judge. We have a negotiated plea ready. I received correspondence as I was driving to court from Ms. Ross. I just need to call her. There was a little hiccup with his TB test for the program. So we should be able to handle it today, but I need to speak with her first.
Okay. I was curious about him because he had so many cases. I don't remember having so many cases with one defendant. And it looked like some discovery you got really, really late. That's not going to interfere with the ability. It sounds like these are probably pretty similar fact patterns.
Good.
And so you would know what would be coming into, okay. All right, great. So that's a plea, but we got to work through that one piece. And then I think that Ms. Cabrera is not going to be here today because she has picked it. She's in trial in Douglas County.
That's my understanding. I talked with Deputy Abadi, and he's also in trial. He said he'll come and make an announcement, but his belief is that she is in trial in Douglas County.
Okay. So is there anyone here for Mr. Cherry or for Mr. Baker? Nope. You're here for Mr. Baker? Okay. His lawyer, Ms. Cabrera, is in trial right now in Douglas County. So I'll bring Mr. Baker out just to the door so you can see him. You guys can't talk, but you can wave and let him know that we're going to have this conversation that we were going to have today at another time when his lawyer can be here. But she's not on vacation. She's in trial in Douglas County. It sounds like you said Mr. Abate would be coming here?
He did say that he would try and sneak away and come up.
Oh, well.
He was here, then realized court was not until 9:30. And then
I don't know why we were 9:30 today. We're usually 9, but this was 9:30. So here we are, just mixing it up for you all. If you get a sense that he'll be here, then we can wait so that Mr. Baker I can talk to him when Mr. Abate is going to be here. I don't want to make family wait too long, but let's just see if he can be here. We'll just stop whatever we're doing, bring Mr. Baker to the door. Otherwise, I think after we knock out a few of these things, we'll take care of Mr. Baker's situation. And it's not your case, but is Mr. Baker co-defendant with Mr. Pierce?
I think so.
Okay, because Mr. Pierce needs to catch up. He wants to have a Ferretta hearing. I'll look it up, but Mr. Abate's here. Good morning. We'll handle your two things right now so you can get back to where you need to be.
Yes, sir.
Ms. Cabrera is in trial like you are, but not in this building, so she won't be here. I'm going to bring Mr. Cherry to the door just to explain. And then Mr. Baker has some family here so they can see him. And then you can be on your way. Where are you in trial?
Judge Emerson with Miss Love.
Oh, you're handling that?
Yes.
Okay. The Harrison case?
Yes, sir.
Okay. All right.
And I had spoke to Miss Cabrera, I want to say Sunday or Saturday. And I knew she was gonna have trial in Douglas, but she had indicated that when she's done, Mr. Cherry had agreed to a plea to the indictment in the state's offer.
Would that resolve all his cases or just this one?
I think we could make it effectively resolve all of this case.
Okay, because there's one, and I know this is the most serious charge, but there's one where I think he shot an officer or was shot by an officer or both people got shot. Significant enough that I wasn't sure it would necessarily fold in, but if he's pleading to the indictment, it would seem like everything could fold in.
Yeah, it could all run concurrent, I would agree.
Okay. All right. Well, we won't put him on the spot for that, but I'll let him know. Let me look up one thing. And then Brandon Baker, well, you'll know, Brandon Baker, does he have a co-defendant, Mr. Pierce?
Yes.
Okay.
Ricky Pierce, yes, Your Honor.
All right. Why don't can we bring Mr. Cherry to the door, please? Great. You think Harrison will finish this week? That's what someone told Judge Emerson.
I think we'll be done by Thursday.
Okay.
So I think less, 8 witnesses.
All right.
That's if Miss Love doesn't complicate it.
Her estimates, I usually have a multiple I attach to them. So, Ms. Wood, while we're waiting on Mr. Cherry, it sounds like we may need to have a conversation, you, me, and Ms. Reimer, and we can either, if it's a day we could bring Mr. Williams over, we will, or we'll patch him in via Zoom. I don't really know what will happen at the hearing. I mean, you have certain rights, and that's sort of where we are, but we'll have a conversation.
Yes.
No, he can be right there. Hey, Mr. Cherry.
Yes, sir.
How are you? I'm Judge McBurney. We met before. I don't know if you remember me, but I remember you. I just want to let you know, we brought you over today because you and your lawyer, Ms. Cabrera, and I, and the prosecutor, Mr. Abate, we're going to have a conversation about moving your cases forward. But it turns out that Ms. Cabrera is in trial in Douglas County. There's something that they picked a jury yesterday, so she's doing her job like she will for you, for another client there. So we're going to reset this in the very near future. It sounds like you and Ms. Cabrera may have agreed on something, working it out with the state. I don't know, and you don't need to tell me anything about that. But when Ms. Cabrera is freed up from that Douglas County trial, then she'll talk with the prosecutor again, and we'll get you back here to either have the conversation we were going to have today about, are we working this out, or should we bring you in for trial? Because you're on my March trial calendar. So if you're not working it out, then in just a few weeks, we have a trial. I know you have several cases. This would be the case where you're charged with murder, not the other ones. But it also may be that you and Ms. Cabrera are working something out. I'm here for either thing. And we were supposed to talk about it today, like I said, but this trial came up, and so Ms. Cabrera is where she needs to be. So I'm sorry you got brought over here. It wasn't to just move you around for no reason. But when she's freed up, we'll get you back here and we'll sort out what's happening. Any questions? All right, thank you. If we could bring Mr. Baker out. Mr. Marks is defense counsel?
Yes, Your Honor. Very brief.
So after we do Mr. Baker, why don't we do Mr. Henley,
Yes.
since he's hanging on the phone? Hey, Mr. Baker, you can come out here. Can you come a little further out? Great. Hey, good morning. I'm Judge McBurney. I think we met before, but I needed to give you an update on your case. You were coming over today for Ms. Cabrera, your lawyer, and me and you and the prosecutor to talk a little bit about the progress of your case. You're on an upcoming trial calendar, but your lawyer, Ms. Cabrera, is in trial in Douglas County, so she couldn't be here today. Not her fault or your fault, but you were already on the calendar, so I figured I'd bring you over to let you know no one's forgotten about the situation. The one wrinkle, and I'm going to need to figure out if I just divide the case up into two trials. We have a co-defendant, Mr. Pierce, and Mr. Pierce has decided that he is a sovereign citizen and that he wants to represent himself. So he and I are going to have a conversation in the next couple of weeks about self-representation, which is generally a bad idea, but it's his absolute right, just like it's yours. I'm not hearing you say you want to represent yourself. Don't worry about that. But Mr. Pierce is making it pretty clear that he wants to be his own lawyer. He's not a lawyer, but he wants to do that. And someone who wants to do that after we have the right conversation can do that. But it generally makes sense to try co-defendants together. So I need to get Mr. Pierce through that conversation to see, are you going to have a lawyer or are you going to represent yourself? And if he sticks with representing himself, then I need to make sure he gets the discovery, all that kind of stuff. If that's taking too long, then I may need to say we're going to sever, as the term you use, and your trial will go forward independently of Mr. Pierce's. But right now you are charged together with the same murder, and typically that would mean you and Mr. Pierce go to trial together. Okay? But I need to see which way Mr. Pierce is going with all that. I know that's not your business, but I wanted to give you that update. Ms. Cabrera would tell you the same thing if she could have been here today. Okay? Any questions?
Appreciate you.
Okay, you had some family here. They just wanted you to know they care. And we'll get you back here soon when Ms. Cabrera is freed up.
I want to hear from y'all to she do with David County, right?
Correct. She's got to get through with Douglas County, and I got to get through with Mr. Pierce. Figure what he's doing. Then we'll bring you back here and we'll figure out, is it a trial with both of you or, pardon me?
Say the 13th.
Yeah, that you're on that trial calendar. I don't know that that's going to happen. Final plea was today.
Okay.
But don't worry, you're not missing your final plea because Ms. Cabrera is not here. I just moved that forward.
I understand.
Okay?
I wanted to make sure my family understood where you come.
Yep. And I'll answer any questions they may have. Okay?
I got you. Thank you. Have a blessed day.
All right. You too.
And Ms. Cabrera has been negotiating on his behalf pretty strenuously over the last couple of weeks, so.
Okay. You would have a better sense, is this, one that, likely both will go to trial, one will go to trial? I mean, Mr. Pierce is a little bit of a card now.
Capability pretty similar, to be one that, the idea would be together, root issues, things of that nature, but Mr. Pierce's new sovereign citizen,
Yeah, I don't know if you get some of the, it was just mailed to us, so we'll get it in the docket, about a 20-page thing listing all the reasons why there's no jurisdiction over him, et cetera. So we'll work through that. But I think that's the next event will be to get him here for his Ferretta hearing.
Yes, sir.
Okay, thank you.
Yes.
Ma'am, did you have a question?
Yes, Mr. McWordy, thank you for everything that you're doing, but it's just me and my sister, and we're clueless. We have no information, we haven't heard from anybody in a year. We don't know what's going on.
Okay, well, do you have Ms. Cabrera's contact information?
So,
All right,
I'll give Ms. Cabrera your phone number.
yeah, if you'll give Mr. Abate, that's the prosecutor, and if you do that, she'll be able to reach out to you.
thank you.
I'll answer that.
Thank you.
I'll show how to contact you Monday.
Thank you.
Thank you, you may.
Thank you.
All right. Good morning, Ms. Rivers.
Good morning.
You ready to get something on the record?
Yes, I am.
All right, let's do that. This is position 1 on the calendar, State versus Brian Henley. It's 22 SC 182594. Mr. Henley is appearing through Zoom in his car. His lawyer, Ms. Wood, is here in court. And the prosecutor is here in court as well. Can you either move over one or move the camera so Mr. Henley can see you?
Oh, yes.
However you want to work it. All right. So Mr. Henley, today is your final plea date. And what that means is that up through today, if you decided that you wanted to enter a plea, and the sentence I gave you was more severe than what your lawyer asked for, you could withdraw your plea with no questions asked. So let me give you an example. Let's say the recommendation from the state in this case was 5 years probation, and Ms. Wood asked for 3 years probation. If I were to sentence you to 4 years probation, That's more than what she asked for. And you could say, nope, I'd rather go to trial and no harm, no foul. We just move your case to a trial calendar. After today, you can always enter a plea. You could do that in the middle of a trial. What changes is that you may not withdraw that plea if you don't like the sentence you get. Just like if you go to trial, you don't get to say, I withdraw my guilty verdict because I don't like the sentence you give me. So if you are saying no thanks to whatever the state's offer is today, that's fine. It just means you go on to our April trial calendar. That's where your case will appear. Ms. Wood, do you have all the discovery that you're aware of in Mr. Henley's case?
Yes, Judge.
All right. Ms. Dilligard, what is the state's offer if Mr. Henley wanted to plead today?
The state's recommendation is 6 years probation.
6 years probation, and that would be what, 5 plus 12 months, or you can, is count one something where you can get more than 5 years?
I think it's 1 to 10, if I'm not mistaken.
Okay.
Yeah, it's 1 to 10.
1 to 10. Okay. So it's 6 years probation. Any special conditions?
Yes, Judge, there was some 50 hours of community service, a fine, I believe a Fourth Amendment waiver. Yeah, 50 hours of community service. There's a drug eval and treatment as prescribed by probation, and a Fourth Amendment waiver.
Okay. No fine, or the
No fine.
fine? No fine. Okay. So Mr. Henley, as I understand it, if you were to enter a plea today, the state would recommend 6 years probation, 50 hours of community service, drug and alcohol evaluation, and any treatment that might be recommended. That would not mean drug court, don't panic, but it would be whatever treatment they did recommend. And then a Fourth Amendment waiver, which just means you could be searched while you're on probation if there's a reason to do that. Do you feel like you understand the terms and conditions of the state's offer?
I understand the terms.
Okay. Is that something you're interested in pursuing today, or would you like this case to move to the trial calendar?
We can go to trial. I don't want to accept that.
Okay. And that's something you discussed with Ms. Wood. You're not surprising her with this answer?
No, sir.
Okay. All right. As I mentioned, this will be on the April trial calendar. That's called early in April, and I don't remember exactly when the trial starts, but I would see you again. You need to be here in person, not sitting in the front seat of your car, for the call of the trial calendar on April 3rd. Okay?
Yes, sir. Yes, sir.
Ms. Wood, anything else on behalf of Mr. Henley?
No, Your Honor, thank you.
Okay. Then we'll see you then. If for some reason things change and this is going to be a plea, no need to wait all the way until April 3rd. We can get you in here. Or if it's a probation plea, you can always take the plea virtually and then report to probation at the appropriate time. Anything else on behalf of the state?
Nothing further, Judge.
Okay, Mr. Henley, you are free to go.
Thank you, sir. You have a good day.
You too. All right. Would you like to do Mr. Lim's plea because he's online? You needed to talk to someone.
Just briefly, Judge.
Okay.
Yes.
He's,
So I will, if he can just drop off, I'll give him a call.
Mr. Lim, can you unmute for a moment?
Yes, sir.
Good morning. Your lawyer, Ms. Good, wants to talk to you briefly before we do this plea. So if
Okay.
you don't mind dropping off the call, the Zoom, she's going to call you, speak with you, and then you can get back on and we'll do the plea, okay?
Yes, sir. Thank you.
All right, bye-bye.
So like this was the last one he was arrested on, and then, so he's on probation.
I see.
It's the last one arrested. Mm-hmm. Okay.
All right. Do you want to do, while we're waiting on that, the Carter plea? Is Miss Carter here? She is. Hey, Miss Carter. Why don't you come on up? change our little cameras here. All right, let's get on the record. This is 24. Are you ready? I don't mean to rush you. Okay, 24 SC 004688. State versus, is it pronounced Sheena?
Yes, sir.
Sheena Carter. Ms. Carter is here in court with her lawyer, Ms. Rios. Ms. Dilligard represents the state. And in a moment, Ms. Carter, Ms. Dilligard is going to put you under oath and then ask you a bunch of questions about your rights, things you and Ms. Rios have already talked about. You'll need to answer all her questions. I'll probably have a few. You got to answer mine. But if at any point you have questions, it's important that you let Ms. Rios or me know so that we can try to answer those questions. Will you do that?
Yes, sir.
All right, Ms. Dilligard.
Ms. Carter, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name for the record.
Sheena Carter.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you and how far have you gone in school?
41, 12th grade.
Did you graduate from high school?
No, I had a baby.
That's all right. That's another important life event.
Yes.
Do you understand that you have been charged with the following offenses as charged in the indictments? Count one is one count of aggravated assault and one count of possession of a firearm during commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the charges in this indictment against you, including the facts and circumstances related to these charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any defects within for purposes of the plea?
Yes.
Do you remember being arrested on these charges, Ms. Carter?
Yes.
Has your attorney advised you at the minimum and maximum sentence for each charge to which you're pleading guilty today? So as charged in the indictment, count one, the range is 1 to 20. And for count two, the range is 5 consecutive to count one. Judge, with our negotiations, we have agreed to reduce count one to reckless conduct and reduce count two to disorderly. The range on that is 1 to 12 months for each count. Do you understand?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, as recently mentioned, for count one, the state is recommending to reduce aggravated assault to reckless conduct pursuant to OCGA 16560. And for count two, to reduce to disorderly conduct pursuant to OCGA 161139 for 12 months probation.
Total?
or concurrent total.
Okay.
Yes. The conditions is 50 hours of community service to forfeit interest in the gun. 12 hours of anger management within 90 days of taking the plea. A gun safety class within 90 days. No contact with the victim in this case. Not to possess any firearms or replicas thereof, and to stay away from the incident location.
So a gun safety class and not possessing firearms, they're not they're not completely inconsistent.
Yes.
One means don't have a gun in your house or in your car, but at a gun safety class, Ms. Carter might need to be handling guns. And so I wouldn't want her to think I can go to the class, but I can't touch anything.
Okay.
So I don't know how you want to,
So
if it would be no guns other than at gun safety class.
that's what I think.
Okay.
Yes, ma'am.
Okay.
Okay, is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand if there are multiple charges to which you're pleading guilty today, that the court has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your guilty plea?
Yes, ma'am.
Are you on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
You understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
You understand if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
And do you understand that you're not allowed to possess or use a firearm while?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Ms. Carter, how do you plead to the reduced charge of reckless conduct and disorderly conduct in indictment number 24 SC 004688?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the facts would show that on August 26th of 2022, officers were dispatched to Cook Park, located at 616 Joseph E. Boone Boulevard Northwest. They met with the victim in this case, whose name is Tiffany Farrell, Ferell. They also met with the independent witness, Miss Shirlasia. It's Shirlasia King, who both said that this defendant at the park, they got into a verbal dispute. This defendant sent her son to their vehicle to retrieve her firearm. He brought the firearm back to her. A reason for the plea is there's some dispute in the evidence whether or not she pointed that firearm at the victim. But there was a firearm that was retrieved from her vehicle during this verbal altercation at the park. As the court is also aware, because this was originally calendared for a motion to suppress, there are some evidentiary concerns for the state. And so that's another reason for the plea in this matter and how we've negotiated. And all this occurred in Fulton County, Georgia.
All right. Have you or someone in your office had recent contact with Ms. Farrell?
Yes, Judge. I've spoken with her a few times. She understands the negotiated plea and the reasons thereof. And her only statement to me was that she didn't want to take this mom away from her children. So
Okay. And she's okay with the no contact. These aren't people who need to interact because of business or shared friends or anything like that.
No, Judge.
Okay. All right. Thank you. Good morning, Ms. Jackson. How are you?
Good morning, Judge. I'm great. How are you?
I'm doing all right. Can you share with me any criminal history information you have on Ms. Carter?
Yes, sir. She has 27 cycles. The last arrest was July the 4th, 2020 with the City of Atlanta Police Department for simple battery, family violence. There was no disposition for that arrest. She did receive first offender treatment for a felony in 2001 for theft by receiving stolen property. The seal date was not listed in the GCIC. She does have misdemeanor sentences and convictions. There was a conviction in 2017 out of DeKalb County for simple battery. She received a no contendory sentence in 2013 out of Gwinnett County for driving while license suspended or revoked. And there was a conviction in 2013 out of DeKalb County for reckless conduct. And she received a no contendory sentence in 2009 for possession of marijuana less than an ounce. And there was a conviction in 2000 for theft by shoplifting. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Rios.
Yes, Your Honor. Ms. Carter is 41 years old. She has 5 children. Her 3 youngest children are 14, 7, and 6, and
Yes,
they
ma'am.
reside with her. She's currently working for a temp agency doing different odd jobs for them. We're asking you to accept the plea as negotiated. With the situation, when I looked at the video, that's why we had the negotiation, is the victim said that she never pointed her gun at her. And I understand later she's changed her story, but when the cops first asked her, she said she got the gun but never pointed it at her. My client was adamant that she wouldn't be pointing a gun at anyone. It was a situation where she said they brought a gun too, so that's why she retrieved her gun. It was just self-defense. She had her child there. And so we're just asking for you to accept the plea as negotiated.
Okay. Ms. Carter, which of your kids was it who was there who you said, go get my gun from my car?
It was he's 19 now.
Okay, so it wasn't like a
No,
4-year-old.
No, sir, the party was for the 14-year-old, so we were setting up a birthday party for him. I don't know the victim, never met her before, never seen.
Complete stranger.
Complete stranger. We had altercation words because of her boyfriend at the time. I don't know them.
You didn't know the
No,
boyfriend?
neither
either.
one. I was explaining to her that he was making gestures at me and it was words passed, the gun was pulled out. I got my gun just for my sake, but I don't point weapons. I mean, my record, I'm a hands-on person. I don't do weapons.
I was
like
gonna
that.
say, you got a record. It's
Yeah,
not shooting
I'm
people.
not gonna lie. I
Hitting
don't,
them.
yeah, I don't do weapons.
Okay.
So no.
That's a good choice. Talk to me a little bit about the criminal history. 27 cycles means you've been arrested almost 30 times in your young life.
Yeah.
And I ask not because, gosh, I'm disappointed in you. I'm not judging you that way. But often when I am working with someone who has that many arrests, there's an alcohol issue or there's something, and I want to make sure that whatever sentence we're putting together here addresses things that are causing you to get arrested. It also could be, hey, when I was 17, I was a wild child.
That's exactly what
and I would get arrested every week because I was drinking or doing this or that. Because most of these things are old. The most recent one was from July 20, this family violence battery that
My
she's
sister.
putting hands on people. But you got 5 kids and
Yes, sir.
3 of them are minors and they need you around and not getting locked up.
Yes.
So is there anything we're not addressing in this sentence? Like, hey, maybe going to AA classes or something like that?
No, you hit the nail on the hammer on the nail. It was just me being wild as a teenager. I just wanted to act out.
You're less wild now?
I'm very less wild now. Very much more mature.
Okay. Would your sister say that you're less wild now?
Oh, I speak with all my sisters.
The one that you
Yes.
smacked back in July of 20?
We're all family.
Okay.
Everything is mended.
All right.
I ain't putting my hands on nobody.
Okay. All right. Well, that's helpful. I appreciate you assessing your life that way. Just because that was a lot of arrests for in particular a female. I'm not getting into gender bias. It's just usually young men who are getting arrested again and again. And you were an exception to that
I
rule.
wanted to hang with all the boys when I was younger. so-
Well, and you ended up where all the boys.
Yeah, I definitely did. And I
Okay.
learned my lesson the hard way.
Well, it sounds like it took a little while to learn, but here we are. Okay. And I'll also note, this is old, this case. I
Yes,
mean,
sir.
It took the state a little while to indict it. So we're here now with hey, this is a recent indictment, but this is something from August of 2 years ago. And it doesn't sound like you've had any issues.
I don't
since
want to
then.
get in no more trouble, no.
Good. All right. Well, I'm with you on that. Anything you want to add?
I'm just trying to better myself. I'm working. I've been working for the election, so I'm definitely staying out of trouble. Can't have any record with that. And
They pay you for election work?
Yes.
Is it pretty good?
Mm-hmm.
Okay.
Yeah.
But that's only part-time. I mean, we don't have
We
elections
work
right now.
We do different things. So sometimes we do community activities, community events, we organize things. It's just different activities. So by
Okay.
me doing that, it keeps me away from the negative side
Good.
and focus more on my kids and the positive things.
Okay. All right, well, let's hope that continues. Well, Ms. Carter, I find there's a factual basis for your plea to reckless conduct and disorderly conduct. Sounds like at a minimum that was going on. It may have been there were some other people who were disorderly as well, but you're the one who got arrested.
Mm-hmm. My mouth.
I also find that your plea is knowing and voluntary. That means you've understood what we talked about and that no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Then I will accept it. Ms. Rios, may someone in my office sign the indictment on your behalf?
Yes, Your Honor.
And Ms. Dilligard?
Yes, Judge.
Ms. Carter, is it okay if someone signs your name to the indictment
Yes, sir.
indicating your plea to the 2 misdemeanors?
Yes, sir.
All right. Then I will follow the negotiated resolution and sentence you on count 1, which has been reduced to reckless conduct, to 12 months probation, and count 2, reduced to disorderly conduct, 12 months probation. Those will run concurrently with each other. That means at the same time. Special conditions of your probation. Number 1, 50 hours of community service. And you should think about where you want to do that, because if you just go to probation and say, hey, I need to do community service, they'll give you a stick and a bag and you pick up trash on the side of the road. You could do that, but you may have a church or a community center where you could volunteer and it would be more meaningful for you as well as the people who you're helping.
Yes, sir.
So if you identify a place like that, just check in with probation. And if they say, yep, you could do that, then you can do your hours in a way that might not make the streets quite as clean, but will be better for you.
Yes, sir.
So up to you. You'll also have to do 12 hours. This is the first time I've had an hour requirement, but we're going to do that. 12 hours of anger management. Looking at your criminal history, probably 30 hours would be good, but we'll go with 12. And you need to have enrolled in that anger management within the first 90 days of your probation.
Today.
So it's more than just one class. If it's 12 hours, that's going to be more like a seminar.
Yes, sir.
Make sure you do that. You're going to forfeit whatever gun was seized if one was seized. And you'll need to take a gun safety class. That might only be 1 hour. You find the gun safety class, you take that. Apart from being in the gun safety class, you cannot be around guns. So in your household, there cannot be any guns. If you've got another adult who stays with you and he or she has a gun, that's got to be out of the house if that person's going to be living with you.
Yes, sir.
No contact with Ms. Farrell. Sounds like that'll be easy because you guys are strangers. But if you find yourself back at Cook Park and lo and behold, she's there, you got to just walk away. And like you said, you zip it and we leave it that way.
I think she's not supposed to go back to that incident.
I don't even go over there.
Oh, we're staying away from the.
Yeah, we've been staying away from there since that day.
Sorry, stay away from Cook Park as well. Go to other parks.
I don't even live over there no more.
All right, well, good. That'll make it easier. No field trips to Cook Park. I think I covered everything. Anything else, Ms. Dilligard?
Nothing further, Judge.
All right, Ms. Rios?
Nothing else. Thank you.
So last thing then, Ms. Carter, misdemeanor probation is run by our organization. Come to court. We've got felony probation right here, but you'll be on misdemeanor probation. You're going to get information. You may get an email from them, but it'll probably come from Ms. Rios.
Okay.
Whatever it is, if it's been a week and you haven't heard from anyone,
Call Ms. Rios.
yeah, call Ms. Rios and say, wait, I need to get started with probation, because you don't want them to reach out to me saying, we can't find this lady, and then there's a warrant.
No.
So just work with Ms. Rios on that. She'll have the information about who you need to call. And it's usually telephonic reporting. You might need to go the first time. Their office is like 2 blocks from here. So it's not like you need to go to Conyers to get plugged in. Okay? Any questions about anything?
No, sir.
All right. Well, let's hope you have evolved from beyond the wild young years.
I have.
All right. Take care.
Thank you. You have a great day.
You too.
Yes, ma'am. Okay. Thank you.
You about to do your plea?
Good morning.
Good morning, Judge. I apologize for my tardiness. I was in Judge Krause and then I've only been here once, so I got lost from you.
Okay. People covered for you. Give me a second. Ms. Wood, are you ready on Mr. Lim?
Yes.
Okay, we're gonna do that in a second. I want to figure out what's happening with Mr. Shanks, which is Mr. Patrick's case. So 2 things. One, I'm happy to see you, but ... I was told Ms. Charles was going to be filling this role. Has that switched and it's going to be you?
As of March 1st, so starting next Monday, it's Ms. Charles.
Okay. I'm happy either way. I'm not saying that to you, saying, what the heck is Patrick doing here? I just, my team and I like to know, who do we call when there is a DV issue? And it sounds like for the next 3 days, we call you.
Yes, Judge.
Got
So I was in your courtroom for a couple of weeks. This is my, third week, fourth
Yeah.
week now. So we've shifted up courtrooms and I'm losing you and picking up Judge Lethbridge and Richards.
Okay. A 1 for 2 deal.
Yes, Judge.
Huh, all right. We'd be right next door when you're with Judge Lethbridge. All right, so that was question 1. We'll enjoy you for 3 more days. Question 2 is what's going on with Mr. Shanks? What Ms. Rios told me was that she was hopeful there'd be this global resolution, and that a bunch of things would be accused. But I guess we all need to hear from you. Yes, that can happen, but there need to be waivers, or no, it's going to be indictments, or what? Because should we bring Mr. Shanks out to hear all this?
Yep.
Okay.
We don't have court on Friday, do we? Take off, so take my mom out.
You can just come in a little bit. We're just talking structurally, whatever that's fine. Hey, Mr. Shanks, how you doing? So we're just talking through what's going on with your case. Ms. Rios explained to me that you've got a few unindicted cases that are trying to get indicted so you can resolve everything together. And I wanted you to hear everything we were talking about, okay? So Mr. Patrick, tell me what the state's doing in terms of indicting or accusing the various PI cases we've got.
Yes, Judge. So I guess the first thing is I'll fall on my sword a little bit here, and I didn't understand the Odyssey stuff the way I thought it did. It was different than when I was in the solicitor's office years ago. And terminology in Fulton is different than the terminology from the circuit I came from.
Okay.
So I was aware of 2 PI cases, 24 PI 007151 and 7152. Those I drafted accusations on, which according to the clerk's office are not done exactly right, and I'm gonna have to file those down. I'm gonna endeavor as soon as I get out of here to find out what that means.
Okay.
But Ms. Rios brought to my attention there were others that I quasi didn't know about, had seen with DWAP, dismissed without prejudice. Apparently, according to my supervisor, I just hung up with, in Fulton County, that doesn't mean what it means in the DA's office, doesn't mean what it means in the solicitor's office or where I came from. Where I came from and in the solicitor's office, that means the prosecuting attorney had dismissed the case. She asked the question just to clean it up so that when he's done, he's done.
Right. There's not a surprise case that reaches out and grabs you after you get out. We don't want that.
Exactly. I don't want
Okay.
that either. And to her credit, she asked, are we gonna clean them all up?
Yep.
I didn't think that was a question to ask because it's, if the DA's office has dismissed it, why would the DA's office accuse it?
Right.
So at this point, I think what I would like to do, and I hadn't talked with Ms. Rios, I know you've got a Zoom calendar tomorrow.
I do.
And it's a jail Zoom calendar.
It is.
If you're okay with it, can we put Mr. Shanks on that calendar so I can figure out? I never thought I'd announce this in open court as a grown-up and a lawyer, so that I can figure out what words mean.
Okay. So the answer is we can, but rather than drag Mr. Shanks into one of those booths for you to say, yeah, I'm going to accuse things, do you think that between now and tomorrow afternoon, because it's an afternoon calendar, there is a likelihood that you would successfully get accused and case numbers assigned to, or on the record say, the district attorney's office will not proceed with case 24 PI 1234, because that'll also suffice. If it's on the record that you're not going forward with it, then if later on a successor of yours does, Ms. Rios, on behalf of Mr. Shanks, could say, on the record, they said that's a dead case. And so either things could be accused by tomorrow afternoon, or you'd be in a position to say, now I know what words mean, and we, the state, are forever walking away from this particular case. We're going to charge this one, walking away from this one, and there's this indicted one that we're going to work through.
Yes, Judge. As soon as I leave here, I'm going to go get with my supervisor and figure out, one, just how things work like this.
Sure.
I thought I knew, but clearly I don't.
That's okay, learning curve.
And just the mechanics of how a case is filed in Fulton County in the DA's office. Like I said, when I was in the solicitor's office, you hit a button and it's all done.
Yeah. No such button.
No. So yes is the direct answer to your question. As soon as I get out of here, we will do what we need to do.
Okay.
To draft. I mean, I can accuse it if he wants to enter a global.
Well, we can get on the record right now any waiver if that's what we need to do. But so your goal would be for tomorrow afternoon's Zoom appearance for Mr. Shanks. Whatever global resolution you all have negotiated, we'd have the pieces in place to take the pleas in those cases, and then whatever dismissals or NPGJs, whatever term you're going to use from your office. Okay.
Yes, Judge. We can make a charging decision for sure.
Okay.
And if it's an accusation, then we can certainly, that'll give me enough time to, there's something called a green sheet.
Yep. I know what those are. Ms. Rios, do you feel like you know all of the unindicted cases attached to Mr. Shanks?
So my question would be what do you need from me if waivers need to be done? And then, because I need to discuss with him, because I haven't discussed with him agreeing to the waiver, and that's fine, we'll talk. And then which ones are you dismissing the DWAP ones? And then, because initially I talked to him just about 2 cases, because those are the 2 cases that we talked. When I start looking more, I was like, oh. And so I need to know what I need to have a conversation with him about, which case we're pleading to.
Well, why don't we do this? I don't want to keep Mr. Shanks standing with the door leaning on him. I have a plea ready to go with Ms. Wood. And while I'm taking that plea, you guys can go to the jury room, wherever you want to be. You and Mr. Patrick can talk about both what's the universe of cases.
Yeah.
And then 2, what does the state need from you? And it could be after you get a chance with Mr. Shanks, on the record, I waive indictment so that he can go forward with that. We can paper that over later.
Yeah.
But if the goal is to try to do this for the Zoom calendar tomorrow afternoon, time is a little bit of the essence. And so I'd want to have Mr. Patrick off moving forward with that after you all have had a chance to talk. Would that work?
Yeah.
Okay. All right. Mr. Shanks, do you have questions about what we've been discussing? We said a whole lot and you've been patiently listening. She will talk to you first, and then she's going to talk with Mr. Patrick, and then she's going to talk to you again so that you can understand the lay of the land. And I want to be real clear. Nothing happens without you and your lawyer saying, yes, this is what we want to do. I'm not making decisions for you. I'm just trying to see. I was under the impression that we might be able to. You have a bunch of cases. That's the issue. I don't know what you've been getting into, but you have a bunch of cases. And Ms. Rios is trying to resolve all of them at once. So it's not that you come in here and you plead guilty and I give you a sentence and you think, great, I'm getting out. And like, nope, you're not getting out because you got this other case. And then you got this other case. So Ms. Rios is trying to get them all rolled up into one outcome. Okay? So she's going to come talk to you. Then she'll talk with the prosecutor. And then she'll come talk to you again. And it may be, I can't promise this, but I'm hoping for it, that I would see you again tomorrow, but it would be on Zoom. You'd be in one of those booths out at the jail and we'd be working everything out. Does that make sense? Okay. If it doesn't, after you talk with Ms. Rios, you can come back out here and we'll talk more, okay? All right.
Okay.
I didn't want to ambush you.
Yeah. No, I haven't talked to him first because I don't, yeah.
I will patiently wait since that's been waited.
All right. All right, you guys are gonna hit the jury room.
Okay.
Yeah, I thought he wanted to talk to you. You want to talk to Mr. Patrick
I
first?
feel like I'll have more information after I talk to him.
Okay.
than talk to
That's all good. Yes, ma'am.
Hi, I'm Christopher's mom. Never met you.
Yes.
Okay, if there's any chance that I can talk with you or.
Yeah, you're on, okay.
You definitely can. So you're gonna talk with the prosecutor and then she'll talk with you, and we'll figure out what we're doing. Do you follow what I'm trying to do, just to try to resolve everything at once?
A little, not much, that's why I'm gonna talk.
Okay. Well, if you've got questions after you talk with Ms. Rios, let me know.
Yes, thank you.
Okay. We ready on Mr. Lim?
Yes, Judge.
All right. So we're good for right now. Let's.
Yeah, we will take it.
All right, Mr. Lim, if you would turn your camera on.
Hello.
Hello.
Let's count them up.
All right. You do that and get your lawyer on. There she is. All right. Mr. Lim, can you hear us?
Yes, I can hear you.
Okay. Are you able to be where you are standing for the next 10 minutes?
But yes,
You can still be able to stay for the next 10.
yes.
Dilligar, are you ready?
Judge.
Good?
Yes.
All right, this is position 3 on our calendar, 24 SC 000-382. It's State versus Lim. Mr. Lim is appearing virtually. What are you outside of?
My work. I'm sorry. The wind, is it distracting? Should I?
No, it's not distracting at all. I was just trying to figure out what that big fancy building is.
Oh, it's actually the Swanee City Hall. I work at the town center.
Okay.
Yeah.
All right, no, you're fine where you are. Mr. Lim, you are ready, it sounds like, to enter a plea in your case, is that right?
Yes, sir.
Okay, before we can do that, I need you to tell me that you are comfortable proceeding virtually. You have a right to be here in court, but you're appearing sitting outside the Smyrna City Hall. Are you waiving your right to be here in court?
Yes, sir.
You also have a right to have Ms. Wood, your lawyer, seated right next to you so you could ask her questions if questions come up. But she is seated here in court. If you need to talk to her, we can arrange that. But are you waiving your right to have Ms. Wood by your side for this plea?
Yes.
All right, you'll let me know if you need to talk to her?
Yes.
All right, then Ms. Dilligard's going to put you under oath in just a moment and we will move forward.
Okay.
Mr. Lim, please raise your right hand. Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct, and legal name for the record.
Jin Woo Lim.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken or been given today?
No.
How old are you and how far have you gone in school?
I'm 32 and I went to college but didn't graduate.
Okay. Is English your dominant language?
Yes.
Do you understand that you've been charged with the following offense? It's 1 count of felony theft by shoplifting.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes.
Do you understand if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove that charge against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances relating to that charge?
Yes.
Would you like any more time to discuss the case with your lawyer?
No. Yeah, it should be fine.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any defects for purposes of the plea?
So waived.
Mr. Lim, do you remember being arrested on this charge?
Yes.
Has your attorney advised you at the minimum and maximum sentence for the charge which you're plead guilty to today? For theft by shoplifting, since this will be his 5th conviction, the range is 1 to 10. Is that your understanding?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommended offer from the state is 5-1. And there are some special conditions to that. There's a.
Hold on one second.
I think we have an updated negotiated resolution. If we can do it non-negotiated if we need to.
Okay.
But my understanding is that you would agree to my counteroffer. But we can do non-negotiated if needed, Judge.
Well, and before we go any further, my understanding of a fourth or subsequent shoplifting is that there's a year to serve. That I can't. It's sort of like with armed robbery. It's 10 years to serve. Not that Mr. Lim is looking at 10 years, but my recollection is the statute says it is a year to serve, unbudgeable, unwaivable, et cetera.
Judge, there is case law. I don't know. I'll double check if there's certified convictions. I'm not sure if he was represented by attorneys on all of those. I know there's case law that if he was not, then you can get away from the 1 year to serve.
Yeah.
But if we need to put this on pause and I need to speak with her and him again, I'm happy to do that.
Okay. I think that you're right that needs to be one. I don't know how folks were planning on moving forward, but if the state is seeking to impose the mandatory minimum of 1 year and there is a contest, as in other words, you're saying that he wasn't counseled for those convictions or there aren't certified convictions, then we do need to put it on pause because I'll be imposing the 1 year if it is a plea to theft by shoplifting. I'm required to, and it's a reasonable law when we're on number 5 or whatever we're on. So I don't know if we ought to, then we could certainly take the guilty part and get that in place and then reset this for sentencing so that the state can get its hands on the convictions. I looked at the recidivist notice, so it's really not that, it's the repeat offender notice, and they're all local-ish and pretty recent. I also don't know what the law would be, all these convictions post this occurrence. The date of the shoplifting is from October 22.
Correct, Judge. This is the last in a string of some pretty poor choices on Mr. Lim's part. So that's why we were eager to wrap it up. He does have some other active probation cases.
Yeah. So it may be that we want to, at a minimum, get the guilty part in, and then we reconvene for sentencing. But I don't want to force anyone in a particular direction.
Judge, if we could just pause.
Yeah.
And I step out and give him a call.
Okay.
And then I'll come right back in.
All right. Mr. Lim, sorry for the hiccup, but we're going to have Ms. Wood give you a call, okay?
Okay.
So you should drop off and then rejoin us.
Okay.
Pardon me? Oh, from? Okay. So he should probably come to court. All right. So maybe we could do the guilty plea part and then later on this week, or I don't know how much time it takes to get certifieds from DeKalb. We only need to get 3 of them, but there are 4 out there.
Okay.
2 are from DeKalb.
That and a cob.
Yeah.
Okay.
The DeKalbs aren't all that old. It's just August of last year. So I haven't seen Ms. Taylor yet. I did see Ms. Gladden come in. Have you heard anything from Ms. Taylor?
She stepped up. I'm saying she got something.
No. Ms. Gladden we'll get in a second. What about Ms. Taylor? Can you check with her, please? Thanks.
Because she's getting on Zoom right now.
Okay.
But you're on Zoom. I'm telling you. She's knocking on Zoom now.
Okay.
Justice Perry,
Hey,
I was just wondering if there was no way to change contacts. This week.
you sure can when she comes back out.
I just expired.
Uh-oh, so you got a scoop. If you want to write your contact information down on this, I'll give it to her. Just name and phone, whatever your preferred, if it's phone or email, then I'll make sure she reaches out to you. It's possible that your son will be on a Zoom session that you could watch tomorrow afternoon if they're able to work everything out.
Okay, thank you.
Sure.
All right, thank you. Have a good day.
All right.
Good morning.
Do you want to get Ms. Gladden in here? We could deal with your two cases since Ms. Taylor is now on Zoom while we're holding on limb. Hey, Ms. Gladden.
Good morning, Judge.
Good morning. If you and your client could come on up to the podium. And Ms. Taylor, are you able to hear us?
Yes, Judge.
All right, I'm going to add you to the spotlight. And Ms. Hightower, why don't you come on up and sit at the table?
Oh, Judge, do you want us at the table?
Nope, I want you right there. And if you come sit not at the closer table, unfortunately, but the other one.
But you know what I'm saying.
All right.
Thank you.
We need to figure out how to move these cases forward. Ms. Gladden is here with Mr. Perry and, thought I had that on there. Let's take this off so things fit better. Taylor is here on behalf of Ms. Hightower. Ms. Gladden, glad you're doing better. Have you received discovery in the case?
No, Your Honor, but it's not the state's fault, I don't think.
I don't think it is either. I know you only
Just
recently
filed an entry.
filed your entry, so we need to get discovery to you. Ms. Taylor, have you received discovery?
I am, Judge.
Okay, and you feel like from your review of the discovery, anything missing or it looks complete?
As far as I can tell, Judge, it looks complete. I have talked with the state, and I do want to get with the state just to make sure that I have everything, but it looks complete to me.
Okay, we'll work on getting a set of discovery to you. It'll probably be the usual, it's a link, and you gotta download it, but you know how that works. Okay. This case is on the April trial calendar, so it's more than a month away. Should we just preserve the final plea rights for Mr. Perry and Ms. Hightower and keep things moving along? Does that work for you?
I would appreciate that, Judge, yes.
Okay. Does that work for you, Ms. Taylor? I just soon have the final plea discussion with both defendants up to speed, and Ms. Gladden will get up to speed quickly. I know she will, but she needs to get that discovery first.
Yes, Judge, I agree.
Okay. Then what we're going to do, Mr. Perry and Ms. Hightower, is you'll be back here again on April 3rd. That is the trial calendar day. That's not the day you go to trial, but that's the day we figure out what's going to trial. And that'll be the last time that you can tell me, hey, Judge, we're working this case out where you have the ability to withdraw your plea. If you're going to plead, and you may say, I'm going to trial, but you'll have the ability to withdraw your plea if the sentence that I impose is greater than what you asked for through your lawyer. You face some pretty serious charges that if you are found guilty of after trial would result in a fair amount of prison time. So this is serious stuff. I appreciate you both being here on time. Ms. Hightower, you did a little bit of the eye rolling when I said you need to come back to court, but you need to come back to court. These are serious charges and they're not.
Oh, my blood pressure up.
Okay, well, you're gonna need to be here, and Ms. Taylor is gonna help you navigate all this. But until those charges go away, it's important that you stay plugged in and on time, and your lawyer will help you with that. So I will see everyone no later than April 3rd. You'll get notice. It's gonna be a published calendar. Your lawyers will let you know about that. If something comes up between now and then, please let Ms. Nelson know so that we can try to address it. What will be frustrating is if on April 3rd, when I see you next, one of the lawyers said, oh, I never got my client's statement, or there's this issue or that issue. That's knowable. Ms. Taylor should know that now, but she's going to get with Ms. Dilligard about it. And you, Ms. Gladden, should know it real soon because you'll get the discovery and there'll be a police report that said, I'm making this up, but it says Mr. Perry gave a confession and you don't have that confession.
Yes.
You're entitled to it and you may want to suppress it, etc. I want to know about any issues like that before we get back together again on April 3rd.
Of course, Your Honor.
Okay, any questions about any of that?
I just, Your Honor, when I called saying that I had to be in 2 courtrooms, the only number under your name was I guess your assistant in the front office. I do not have the number for your case manager. Would you prefer I call the calendar clerk?
Yeah, the litigation manager would be the right
Litigation
person
manager.
to call. I'll get you that phone number in just a second.
Thank you.
Email works as well. And I think you've got that because I think I saw email correspondence between the two
Yes,
of you.
I do, Judge. That's true. I could do it.
You can always email her. Ms. Taylor, question. Am my wires crossed, or do you represent Mr. Perry, but on a different case or cases?
On a different case, Judge.
Okay, and is that moving along at the same pace so that it'll be on that April trial calendar, or is it moving at a different pace?
I don't know, Judge. I mean, I haven't gotten any kind of notice on it. I only got a notice on this case for Miss Barunchi.
Okay. Well, we will figure out that because it makes sense. Did you have a sense of that?
Well, the last note I see is a P&A, and so I don't know if that case has gone to final.
Okay, do you have the case number?
Oh, yes, it's 24SC000119.
Oh, yeah, it's right here. Okay, it's on the calendar. So let me look that up.
My laptop just died.
Uh-oh. We put that one, Miss Taylor. I'm just looking at the charges on this one. We put that one on hold because everyone agreed that that is work outable once this case is worked out. No one's going to go forward on that case. It's possession with intent to distribute drugs, and that would fall in line behind a home invasion case. So that doesn't mean there can't be a global resolution. But that, I guess, will require a 2-step process because Mr. Perry has different lawyers for those 2 cases. But
I'm sorry, who represents the state on that case?
Ms. Dilligard, same lawyer, so you'd be working with the same person. I just was trying to figure out why nothing was happening with, I'll call it the drug case for short. And that's because I put it on hold. It didn't make sense to have it move forward with the home invasion case sitting squarely in Mr. Perry's lap.
All right, that's fine,
So,
Judge.
Pardon me?
Another note, Judge. I've got my application for leave ready to file in, and my leave is from March 31st through April the 4th. And I'm hearing you say April 3rd trial calendar.
That's right. So
I can get the leave filed in, if not today, by tomorrow. The application, we're preparing them because now we're having to file them individually by each case. So I'll file it in on Miss Barungi for that. I will be out of the country on that date. On April 3rd. I won't be returning until April the 4th.
Well, if you file a leave, we'll process it. It's not there now, so you're gonna do what you do, and we'll handle it accordingly.
All right, Judge. All right, just want to kind of because I already knew that, but I'll get that in this week, Judge. Thank you.
Okay. All right. Ms. Gladden, anything else on behalf of Mr. Perry?
Not at this time, Your Honor.
Okay.
We're gonna see removing the lead monitor. I've been on it 2 years.
Oh, yes,
He
Judge.
said he wanted to take it off.
My client has been on an ankle monitor for 2 years now. I wasn't here, but apparently you had mentioned that you might address the removals or allowing him to remove it. It costs a lot of money. I think, or do they pay for it or you pay for it? They pay for it or you pay for it?
They pay for it.
Okay, well, it costs the state a lot of money, and it has been 2 years, and he's had no contact with the alleged victims. He doesn't even know where they are, because it was a rooming house, so they moved from rooming house to rooming house. So I don't think that there's a danger. He obviously lives here, has lived here for many years. I've known Mr. Perry a long time. So there's no danger of him leaving the state of Georgia or leaving the area because of the nature of the crime. I don't believe there's an issue with intimidating witnesses. Again, they move around from place to place. He hasn't had any contact with them or even knows where they are. He did post a bond, had to post a bond. So I would respectfully request that the court consider removing,
Still filed a motion to this, yeah.
Who filed a motion?
Miss Tate.
Oh, okay. I think there was a motion. Was that in the other case, maybe?
No, that was in the because they put it on me when I had the drug case.
Oh, they put it on. Judge, that was in the drug case. They put it on when he had the drug case. Apparently, Ms. Taylor filed a motion, and I'm sure that she would not mind me. I don't know if it's put down for a motion, but making that request of the court.
Okay. I'm just checking all this out.
Tell them about our reports.
But in that case, Judge, that we do have an affidavit from the co-defendant, which may
In the drug case or in
the drug case.
not a co-defendant, but
No, in the drug case, he has a co-defendant, Judge.
He doesn't. It's just Mantrell Perry, heroin, cocaine, gun. There's no co-defendant. Maybe you got another case out there.
No. That case, my nephew was in the car who drug stuff was. I don't know why they didn't have him when they pulled us over. It was 2 of us.
Well, I don't want you getting into the facts of the case.
Yeah.
Talk to your lawyer about that. But,
okay.
You are the one indicted for the heroin, the cocaine, and the gun. So you'll need to work through that. Ms. Dilligard, my thought is that you should do what you can over the next few days to check with the alleged victim or victims in the home invasion case. And I'm inclined to remove the ankle monitor.
Okay.
I just wanted to make sure that this drug case wasn't something that happened since the ankle monitor went on. Stranger things have happened where someone on an ankle monitor gets arrested and then they don't remove it, or there's no bond modification or anything, but it's older. So drug allegations come before he got the bond with the ankle monitor. I'm not saying that the drug allegations come before the home invasion, but just procedurally, he was not out on bond with the ankle monitor when he got arrested for the heroin and the cocaine. So he's basically had an ankle monitor for 2 years and 12 days. That the county's been paying for good reason early on, but more and more we're trending towards, if there's 6 months with no issues, the ankle monitor ought to come off. There may be exceptional circumstances, but if you would please, you are a victim advocate, reach out to the victims, and then if you could, by the end of the week, shoot an email to me, Ms. Nelson, and Ms. Gladden, saying we oppose it, or we couldn't reach the victims, or we don't oppose it, whatever your perspective is, then we'll just work through it via email. And if they weren't able to reach the folks, then ankle monitor comes off. If there's not opposition to it, or the state says we take no position, then the ankle monitor is coming off. If they oppose it, we may need to get everyone together to talk about why, because there may be a good reason to keep it on. But I appreciate Mr. Perry bringing it back up.
Okay, I do too, Judge, because again, that was a motion filed in the other case, but since that one's been put on hold, I don't see why we can't, as you said, address that part of it now. So
Right.
thank you.
So that's what we'll do. So Mr. Perry, I'm giving the state a chance to reach out to the people who are named as victims in the home invasion case. They have a right to be heard, not necessarily, they don't have to talk to me, but to let the DA's office know. For example, we haven't seen Mr. Perry for 2 years. He keeps rolling by our house and making gun gestures with his hand. If it's the latter, you're keeping the ankle monitor on. In fact, you may be just going back into custody. But if it's the former, then you don't need to worry about it.
No, it's our home house.
He was said wherever they live now. He was just using it as an example. An example.
The note in here from one of our field officers, of an incident that's took place on February 7th.
Meaning just a few weeks ago?
Yes,
That's wrong.
Because Mr. Perry is on probation in another case?
yes,
What case is he? Is it a Fulton case?
yes.
What case is that?
22 SC 184916.
Okay. And what are the DCS notes?
He threatened a family member that works for Marta. The family member contacted them.
Okay.
For the victims?
No. This is a different case. Two things. One, Mr. Perry is on probation now for a case from Judge Leffridge.
Yes, I represent him on that case.
Another drug case. What Ms. Simpson is saying is that something happened a few weeks ago where a family member of Mr. Perry's or someone associated with the home invasion case.
Family member of Mr. Perry's.
Okay, all right. We don't need to litigate that right now. Do not talk about it with me. Talk about it with Ms. Gladden. But I appreciate you flagging that, and that may be something Ms. Dilligard wants to learn a little bit more about. That would be a reason.
I would also like to.
Okay, you guys can digest all of that, but that may become part of the dialogue about what to do with the ankle monitor, or modifying the bond condition in a different way. It might be, don't worry about the ankle monitor anymore, but you got to stay away from this family member. Now that would be a Mr. Perry family member.
They lied. My mom, my niece.
Oh, somebody call.
My niece, I know it's like they told my niece that she was going to call and say because my mom out.
Okay, don't talk about it right now. Thank you, Judge.
Okay, sounds good. Ms. Dilligard, if you could do two things in connection with Mr. Perry's case. One, get the evidence.com link or however you're going to do it to Ms. Gladden. And then two, by Friday, just let us all know what's happening, your thoughts about the ankle monitor.
Yes, Judge.
Okay, perfect. Ms. Taylor, anything else? He's long gone. Okay, probably planning that trip. All right, Ms. Hightower, I will see you on April 3rd, okay? I may see you before then, but Ms. Gladden, we'll see what we can do with the ankle monitor.
Okay, thank you, Judge.
All right.
So I didn't know who to serve though. Yeah, I didn't know who.
Okay, we left the limb matter. I didn't mean to leave it that long, but with some lawyers, things are never quick. Tell me what's happening with Mr. Lim.
Judge, we are going to withdraw the plea for now.
Okay.
Do a final plea hearing. I think it's going to be beneficial if Mr. Lim and I can actually connect.
Yep. Face to face.
Yes, like in my office.
Yeah.
So that's what we'll do. Final plea hearing, and then we'll stay on the April trial calendar.
Okay. Mr. Lim, can you reactivate, please?
Yes.
And Your Honor, may I be excused?
Yes, ma'am. Good
Thank
seeing
Judge.
you.
Good seeing you.
Email Ms. Nelson if you want more contact information for her, okay? You've got that email address, and then
Yeah,
she'll give you whatever phone number is best to reach her.
okay. Well, I'm sorry, the report did not give me that email address.
You have it because I've seen you exchange
Oh,
emails
that's
with
right,
her.
you're right, we did exchange email. I'm
Yes.
sorry, Judge, I apologize.
Okay,
It's been a long couple of months.
all right. All right, Mr. Lim, can you hear me?
Yes, sir.
All right, we're getting back on the record in your case and we're heading in a slightly different direction. It sounds like you and Ms. Wood need to talk more about what's going on. And we're gonna instead do what we call a final plea hearing where I hear from the state what its recommendation is. And then it sounds like you're gonna tell me you would prefer for now to go to trial. But that doesn't mean you necessarily will have a trial. It just means you have a little more time between now and April 3rd, okay?
Yes, sir.
All right, Ms. Wood, first, do you have all the discovery in this shoplifting case?
I think I have everything that the state has right now, Judge.
Okay.
So yes.
Sounds good. Ms. Dilligard, I think I know what the recommendation is because I think we started to get into that, but why don't you put on the record if Mr. Lim were to plead guilty today to felony theft by shoplifting, given his criminal history, what would the state's recommendation be?
Yes, Judge. So because this would be his 5th theft by shoplifting, the range is 1 to 10 with that first year being in custody. So the state's recommendation was 5 to do 1.
Okay, and any conditions of probation?
Yes, Judge. The conditions were an anti-theft course, restitution to Dick's Sporting Goods, and 50 hours of community service.
Any sense of, is the restitution $100, $1,000?
I can tell you. It's $1,000.
Okay. So Mr. Lim, if you were to enter a plea today, the state would recommend 5 years to serve 1 year with a balance on probation. And my understanding of the law is that that 1 year is mandatory, not meaning that you couldn't get parole, but I couldn't go below that statutorily. I would need to sentence you to 1 year in custody, followed by 4 years on probation. And then there'd be a few conditions of probation that you heard. Do you understand what the state's recommendation is?
Yes.
Okay. And Mr. Lim, is that something you're interested in pursuing today, or do you want to say no thanks to that? We'll move your case to a trial calendar and you and Ms. Wood can keep talking?
Yeah, I think I would do that.
The latter?
Speak with Miss Woods.
Okay. All right. So as long as you understand that after today, you are still free to enter a guilty plea, can do that at any time. You just wouldn't be able to withdraw that plea if you did not like the sentence that I gave you. You understand that?
Yes.
Okay. Then Ms. Wood will be in touch with you. You guys will probably be meeting face to face, and I will see you at the latest on April 3rd, but it may well be that you and Ms. Wood sort something out with Ms. Dilligard, and then we'll get you in here before then, okay?
Okay, thank you so much.
Any questions?
No.
All right, Ms. Wood, anything else?
No, Your Honor, thank you.
Ms. Dilligard?
Nothing further.
All right, Mr. Lim, you're good to go.
All right, thank you.
You bet. Is Ms. Rios talking with Mr. Shanks?
Last I saw her, she was talking with his family.
Okay,
I'll go see if I can see her.
we're good for a second. I'm gonna get one update from Ms. Wood and then we'll probably take a break.
Yes, Judge.
Yeah, I was saying.
That's right. I'm sorry.
Haynes,
Yes.
what's the status there?
We have a negotiated plea ready to go. He was accepted into Hope House.
Oh,
The issue was when I was headed to court this morning, I received a message that even though his current TB test is valid and good to go, Hope House wanted him retested.
okay.
Our office is trying to work with the jail to take care of that. My thought is that we could take the pleas and just wait until we get the go-ahead. I don't think it's gonna be a situation where they say he can't come at all, since they've already accepted him. But I want to put that on your radar.
Okay.
Because Ms. Ross wasn't sure how long the delay might be.
Got it. So it's a plea to effectively time served. If there hadn't been this hiccup, it would be, is Hope House coming to get him? Your office is transporting him?
That was the other thing. We were waiting on Friday. I was supposed to have the date so I could do a transport order, Your Honor. But we were trying to get him in by next week at the latest. Because collectively on these cases, he's served over 600 days. So he's very eager to go.
I bet.
But yes, so that's where we are right now.
Okay. All right. So it seems like we should take all the pleas and lock it in. And then if we need to modify something because Hope House doesn't work out or whatnot. But my guess is they just need to, I don't know why they need a fresher one, but they get the fresh test. I would think the jail would be able to do that pretty promptly.
Hope so. But
Okay.
yes, I'm good with that, Judge.
Okay.
He can come out.
But, he has a, that's right. Petition that was submitted to Judge Edwards that we can get this fine.
Yeah, I don't think she's in the signing mode.
I was advised of that.
Yeah. I think we should go. I'm glad you flagged that. I think we should go forward because we could be waiting for months and months and months. And that may just be something that disrupts things if she suddenly changes course. But I've been told that she doesn't sign those. Yeah. Not sure what that means for cases where she sentences people to probation, but that's the place to be, I guess. Did you have an update or you need to talk to Ms. Rios again?
I can update the court just procedurally, and then when she gets back in here, I can say this again too, Judge. There were two cases that she knew about that that aren't in our system yet either. The DA's office has not uploaded, entered. Anyway, she knew about them, I did not. I think the end of the story is we're collectively asking to put on to the 4th so that we can try to wrap up everything. Of course, I would honor the plea that I gave her for the 3 cases,
Right.
but I don't want to do that.
No, but if his situation is yet more complicated and it may be that you honor for the 3, but in light of the others, there's an incremental, then there's an incremental. I mean, your plea didn't cover things you didn't know about. So when you say the 4th, you mean March 4th?
Yes, Judge, she gave me that date, and Ms. Charles would be your ABA then, but she'll have my notes.
Okay, because what I don't want to do is have it be the 4th and Ms. Charles says, I don't know anything about this, but I don't know what this Patrick guy was doing.
Yeah, well, yes, Judge, I don't want that either.
Okay.
I try to take pretty extensive notes, but I will also sit down with Ms. Charles.
Okay.
Tell her exactly what's happening.
Got it. Okay.
And I'll hang out for Ms. Rios to come back.
Yeah, and then we'll figure that out. Okay, sounds good. Thank you. Should we bring Mr. Haynes on out?
Yes, Judge, that's fine.
Let's do it. Oh, Ms. Rios is back there. Oh, that's better. Okay, let's bring Ms. Rios out and then we can bring Mr. Haynes out.
And Judge, all of this little bit of a hiccup is gonna be news to him, but he should be fine. I just believe.
Okay. That's an interesting note, Ms. Simpson. Yeah. Hey, Mr. Haynes can come on up to the podium. And Ms. Rios, real quickly, so Mr. Patrick can start getting to work on everything. It sounds like we're going to reconvene on March 4th.
Yes.
And it won't be Mr. Patrick, it'll be Ms. Charles, but he will have transferred all his knowledge and wisdom. You helped him see that there were additional cases, so they've got some accusing to do. Do you need waivers from Ms. Rios, or how do you want to make that? Or you guys, I guess, can communicate through email?
Let us do that, Judge, because here's my fear, is that because I don't know what I don't know, I don't want her to put herself in a position where she has waived the right to indictment.
Okay.
But I will endeavor to make it as streamlined as possible. I just don't want her to waive anything without me being able to say, yes, I know exactly what this is.
Got it. So I'm going to step back from this. We'll make sure Mr. Shanks is back here on the 4th. If between now and then, either of you needs my help to nudge things along with the clerk's office or with the DA or with the PD, let me know. But what I don't want to have happen is we get here on the 4th and Ms. Charles says, I didn't know I needed to accuse these cases or something. Or I didn't get waivers from Rio. She wouldn't get them to me. I trust you guys can sort this out, but if either of you is running into a friction point, let me know, because it would be great to clear all this out.
Yes, and you are okay with handling his probation revocation for if we are able to work something out? It's supposed to be in Judge Richardson, but
Yes.
Okay.
Yeah, can certainly do that. Okay. All right. I'm happy to tell Mr. Shanks that if he needs to hear it from me.
I already talked to him.
You told him? Okay. And you can still talk to him more. We just need to take care of Mr. Haynes right now.
I think he's fine.
He's good?
Yeah.
Okay. All right.
Judge, with that, my business is complete. May I be dismissed?
Yes, sir. Thank you.
Thank you, Judge.
All right. Let's turn to Mr. Haynes. Let's get that out of here. And this on. Okay. All right. Good morning, Mr. Haynes.
Morning, how you doing?
I'm all right. I'm Judge McBurney, and you have a bunch of cases that we're going to try to work through this morning. Ms. Wood told me that you're prepared to enter a plea in those cases with the goal of getting you to Hope House.
Yes.
Where you'll get some real good residential drug treatment.
Yes.
Okay. For us to do the pleas, Ms. Dilligard, who's the prosecutor on your case, is going to swear you in. She's going to ask you some questions about things you and Ms. Wood already talked about. I may have a few questions. If at any time you've got a question or you're confused by something, will you let me or Ms. Wood know that?
Yes.
Okay, then I think we're good. Ms. Dilligard?
Mr. Haynes, please raise your right hand to the best of your ability. Do you swear or affirm that statements or testimony that you give in the matter before this court shall be true, the whole truth, and nothing but the truth? Okay, you can lower your hand. Please state true and correct legal name for the record.
Timothy Bernard Haynes.
Mr. Haynes, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
I've been taking my mental health meds for like almost a year now, so it's starting to work. I'm not feeling depressed and anxious and racing stuff no more. So,
What do you take medicine for?
anxiety and depression. Yeah, that leads up to my addictions. I've been battling with that for some years now.
I bet. But it sounds like at the jail, they've been getting you that
Yeah, I've been on it
medication?
for a year as long as I stayed on it.
Okay.
Yeah.
Do you take the medicine at night or in the morning?
Both.
Both?
Take 3 different meds. Take Effexa, Buspirone, and Clozapine. I got insomnia and sleeping problems, so I take meds before I go to bed. I take
Okay.
anxiety and depression pills.
And in the morning, did you get your pills
Yes,
this
I got
morning?
2 meds this morning. Yeah.
Good. Okay. Thank you.
How old are you, Mr. Haynes?
53.
And how far have you gone in school?
I completed high school.
Judge, do I do all of them at the same time?
Yep.
Okay. Do you understand that you've been charged with the following offenses? In 24 SC 002172, you've been charged with 3 counts of financial transaction card theft, a count of identity theft fraud while using, possessing, identifying info concerning a person, a count of possession of tools for commission of a crime, and a count of criminal trespass and damage to property. In 24 SC 005227, you've been charged with 2 counts of financial transaction card theft, 2 counts of financial transaction card fraud, and 1 count of misdemeanor theft by taking. In indictment number 24 SC 005226, you've been charged with 2 counts of financial transaction card fraud and 1 count of misdemeanor theft by taking. And in indictment number 24 SC 005383, you've been charged with 1 count of entering auto, 8 counts of financial transaction card theft, 6 counts of financial transaction card fraud, and 1 count of possession of tools for commission of a crime.
Yes.
Do you understand those to be all of your charges you're facing?
Say yes for the record.
Oh, ma'am.
Do you understand that you have to plead their guilt or guilty to these charges?
Yes. I'm sorry.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances relating to these charges?
Yes.
Would you like more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any defects within for purposes of this plea?
So waived.
Mr. Haynes, do you remember being arrested on all of these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today?
Yes.
So.
The fees with.
Three.
When I get to talk at the end, I'll talk to the judge about that. Okay, I get to go at the end.
Okay, so for the financial transaction card thefts and frauds, the range is 1 to 3. For the possession of tools for commission of crime, my understanding it's 1 to 5. Is that your understanding, counsel? Okay.
Yes.
The criminal trespass is 12 months. That's on that first case.
Yeah.
Same ranges for the thefts and the frauds in your subsequent cases. You also have a theft by taking misdemeanor. That's a 1 day to 12-month range. You have entering auto. That's 1 to 3 years. I think I hit all the different charges.
Sorry. I didn't mean to make that loud noise. The book, it's a heavy book. It's not my gavel. Entering auto is 1 to 5.
1 to 5. Thank you, Judge. My apologies. Do you understand all of those ranges, Mr. Haynes?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? Judge, the recommendation to resolve all of his cases is 10 to do 2, commuted to time served, with the conditions that he enters and completes Hope House, 100 hours of community service, a stay away from all public gym facilities.
When you say a public gym facility, what is that?
Like all.
LA Fitness or, okay.
Or not just LA Fitness.
But that's what you mean?
Yes.
That in your mind is public, even though you have to show some kind of card to get in there, that's a public gym facility.
Yes.
Okay, so stay away from all gyms?
Yes.
Okay. All right, how's it gonna work out? All right.
No contact with any of the victims. And then there's restitution. I've only been able to make contact with 2 of the victims out of all of the incidents. One victim is Blake Ho. Last name is spelled Howe. It's $100 in restitution owed to him. And then I was able to make contact with one more victim, and I haven't talked to counsel about that one just yet. I just made contact. It's Sudeep, Sudeep, Vakiti, Vakiti, and he's owed $80 in restitution.
Okay.
Do you understand that recommendation to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes. Yes, ma'am.
He's speaking to the microphone.
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes.
Do you understand if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the
Yes.
balance of your sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes. Mhm.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Haynes, how do you plead to the charges of the 3 counts of financial transaction card theft, 1 count of identity fraud, 1 count of possession of tools for commission of a crime, and 1 count of criminal trespass and damage to property in indictment number 24 SC 002172?
Guilty.
And how do you plead to the charges of 2 counts of financial transaction card theft, 2 counts of transaction card fraud, and 1 count of theft by taking in indictment number 24 SC 005227?
Guilty.
And how do you plead to 2 counts of financial transaction card fraud, 1 count of theft by taking in indictment number 24 SC 005226?
Guilty.
Okay. And how do you plead to enter 1 count of entering auto, 8 counts of financial transaction card theft, 6 counts, sorry, 6 counts of financial transaction card fraud, and 1 count of possession of tools for commission of a crime in indictment number 24 SC 005383?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition?
Yes.
And for misdemeanor charges, you have 12 months from today.
Yes.
Okay. Judge, if these cases, and I'll take them one by one, were to proceed to trial in indictment number 24 SC 002172, the facts would show that on December 28th, officers responded to LA Fitness that was located on 5530 Windward Parkway in Alpharetta. Upon arrival, officers spoke with the victim in this matter, Nicholas Conendera. It's Conedera. The victim stated that after returning to his locker, he was missing some of his personal items that he left there when going to work out. It was a wallet and 3 debit cards. Upon returning, he noticed that his cards were missing. He called the bank and canceled them. After taking the report, officers exited the gym to further their investigation. They were also approached by a witness who had found the bag containing a bolt cutter in the locker room. When officers noticed a black male later identified as the defendant in this matter, Mr. Haynes, changing clothes, when asked about the bolt cutters, he responded that they did belong to him. And he said that he uses them for work. Officers questioned. He appeared to be very nervous. Haynes then stated that he threw the bank cards that he retrieved from the victims away. In this case, I've made multiple attempts to reach this victim, however, was not successful. And this also occurred in Fulton County, Georgia. The second incident, which occurred on November 19th, which is 24 SC 005226, officers arrived again to LA Fitness, this one located on 669 Roswell Road. They spoke with the victim, Mr. Ho, Howe, who stated that his bag, again, was taken from his locker that he placed in there when he went into the sauna. When he returned, he noticed that his lock was missing. He opened his locker and retrieved his duffel bag, noticed that his wallet that was inside was missing. He stated there was an American Express card and some other credit cards along with his driver's license and some cash. His bank had notified him that there was a $106.95 transaction at a Publix that was nearby. Officers went to the Publix to retrieve surveillance from the video, which shows the defendant utilizing that card at the Publix right there after the theft. And this is the case that the victim I have made contact with and is owed $100.
Got it.
The next incident that occurred on January 10th, which is indictment number 24 SC 005227. Officers again was responded to a theft call at fitness. This located at 475 Old College Road in Roswell, Georgia. They met with the victim who said that he placed his wallet inside his gym bag and his locker when he went to take a shower. Returned, he noticed that his bag and his wallet were missing. There was a witness that stated the suspect left the locker room 5 minutes prior to the victim's return with his items. He had a bag that was taken, a wallet, some cash, and some cards as well. There's a second victim in this case. The name is Carlos Maurice, who I have not had contact with after multiple attempts. He stated that his card was also taken from the same LA Fitness. There was multiple unfamiliar transactions at a public supermarket for a little over $100 3 times. They reviewed the camera footage from both the LA Fitness and the Publix that identified the defendant as. Lastly, March 18th, which is 24 SC 005383. On March 18th, officers were dispatched to LA Fitness on 6690 Roswell Road on an entering auto call. When they arrived, they met with Jacoby Gambrell, Gambrell, who stated after working out at LA Fitness, he went to his locker to get his belongings. He noticed that his lock was cut off his locker and that his keys were missing. When he went out to his vehicle, it was still there, but it was unlocked and his wallet was inside. He received a fraud alert on his phone saying that his American Express was being utilized at a public supermarket down the street. While they were talking to that victim, another victim by the name of Mr. Xiong, it's Xiong, arrived on scene, stated that he was also a victim and they attempted to break into his locker as well. He stated that he was able to actually confront the defendant and retrieve all of his items at the MARTYR station down the street briefly before. Officers then relocated to the MARTIR station where they took the defendant into custody. A search of his person showed that he had pliers, slip point pliers, combination locks, receipts, multiple gift cards, and multiple debit cards. And that all of these incidents occurred in Fulton County. This last victim, I also attempted contact multiple times, but were unsuccessful.
All right. Thank you.
You're welcome.
So Ms. Wood, I'm looking at the bookings and I see how you've done your math. There aren't, maybe Mr. Haynes wasn't arrested for the 226 and 227. That's the last three of the indictment. One was Mr. Howe, and it was November of 23. There's no arrest matching that.
Right.
And then similarly, fast forward a couple months and we're into January of 24. That's Mr. Vakiti. There's not an arrest in the system either. I don't know what happened there, but
Yes, I noticed that as well, Judge. I'm not sure if they just had warrants and then they were able to get him.
it all caught up with him. That could be it. It also says Hope House in the system for him.
Yes, Judge.
Okay. All right. I've looked at a chunk of your criminal history because you're a repeat offender, so I'm not going to ask Ms. Jackson to detail all that. I'd like to hear from Ms. Wood about you, Mr. Haynes, and then there may be some things you want to add, and we'll figure out what we're going to do. Okay?
Yes, Judge. So he was actually accepted into Hope House in the fall while as a condition of bond.
Okay.
And that was part of the issue because he was not able to postpone. And so then we resubmitted the application. He was reaccepted. He's been in collectively 617 days for these cases. Judge, he's 53. He's originally from North Carolina. He's been here in the Atlanta area since 2005. He does have a high school education. I would ask, he receives government benefits, so I would ask that the probation fees be waived. I would also be requesting a restitution hearing. And Mr. Haynes wanted me to request the court to consider setting a behavioral incentive date for his probation here. Judge, he's just eager to get out and get back into a sober lifestyle. He had completed one of the accountability courts previously successfully, so he believes that he can do well as long as he's got that structure in place.
Sure.
So,
And he's taking his medication.
yes, that's key, Judge. So
Yep.
we would just ask that you accept the state's recommendation.
All right. Mr. Haynes, do you have any questions about anything?
Well, last past 20 years, I've been dealing with a cocaine addiction. So that led me back in and out the jails.
Mm.
And the drug dealers would give me drugs. Then I have to go get cards for them. So that's how I end up so many cards. They
Got
me
it.
the drugs.
So it
Have
was
to pay
drugs
back.
for credit
Yeah,
cards, debit
yeah.
cards.
They give it to them and say, well, you owe me so and so much for these credit cards. So they love the gift cards. So I keep going back, trying to pay them back. They give me more. So it's been a circle for like 20 years. So I'm ready
Okay.
to move on, get recovery, and move on in my life.
Good. We want to break that circle.
Yeah.
That sounds like a bad circle.
Yeah.
Do you have family in the Atlanta area?
No.
No? Where are you
I'm
from?
going back to Charlotte. Like once I complete the drug treatment at Hope House, I'll reunite with my family back in Charlotte, North Carolina.
Okay. All right. Well, Mr. Haynes, I find there's a factual basis for all four of your pleas. You had a routine, LA Fitness, get in the locker, see what you could get, car keys, get in the car, et cetera. You're not hurting people physically. You're not dangerous in that way, but it's certainly real disruptive for someone to have his wallet stolen. I got to cancel my cards. You're worried about, do you have my license? Do you know where I live? So you can understand why people get pretty upset about this, even though it's not holding a gun to someone saying, give it all up. I find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to do this. Knowing means you understand what we're talking about. Is that correct?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Haynes, is that while you're on probation, if you have a small violation, and I hope you have none, but if you have a small one, you and probation will work through that. But if you get arrested for something or you get kicked out of Hope House, something big like that, that'll come back to me.
Okay.
Ms. Wood, can someone in my office sign the 4 indictments for you?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Haynes, can we electronically put your name on for your guilty pleas? All right, we'll do that. Do you have a weapons carry license? No? All right. Mr. Haynes, I am going to structure your sentences as follows. In 24 SC 002172, I am sentencing you on counts. What did you say identity theft fraud is?
They're both 1 to 3.
That's a 1 to 3 also? Okay. I'm going to sentence you on counts. So let's go to indictment 172, like I said. Got to get in front of me. So counts 1, 2, and 3, your sentence is 18 months to serve. Count 4 and 4, so 18 months to serve on counts 1, 2, 3, and 4. Count 5 is 5 years probation. That'll run consecutive to count 1. And count 6 is 12 months to serve. That'll run concurrently, meaning at the same time as count 1. So your total sentence on the case ending in 172, which is it's the oldest of the cases, the gym on Windward Parkway, is a sentence of 6.5 years to serve 1.5 years with 5 on probation.
Yes, probation.
Okay. Special condition of probation will be to enter into and complete Hope House. You'll have to do 100 hours of community service, but you've got 5 years to do that. You'll need to stay away from all gyms, LA Fitness, Planet Fitness, anything that's a gym with lockers, you don't go in, okay? No contact with any of the victims, and I'm waiving your probation supervision fees. In 24 SC 005226, that is the case involving Mr. Howe and you using his card at a Publix. I'm sentencing you on, is the theft by taking a misdemeanor? I think it is.
Yes.
5226, it is, okay. I'm sentencing you on that one to 18 months to serve on count 1, 18 months to serve on count 2, and 12 months to serve on count 3. Those are all running concurrently. In 24 SC 005227, and that is our LA Fitness on Holcomb Bridge Road with Mr. Vakiti. Get that indictment up on the screen. I'm sentencing you to 18 months to serve on counts 1, 2, 3, and 4, and 12 months to serve on count 5. Those are all running concurrently with each other. So it's a total sentence of 18 months to serve, or 1 year and 6 months, it may need to say on the sentencing sheet. And then that gets us to the final indictment, which is 24 SC 005383. That up on my screen. For counts 1 through 15, I'm sentencing you to 1 year and 6 months to serve. And for count 16, I'm sentencing you to 5 years probation, and that'll run consecutive to count 1. Okay. So it is again 6.5 years to serve 1.5 years, followed by 5 years on probation. And the conditions of probation in the case ending in 383 are all the same. Don't go to a gym, 100 hours community service, all the things I already said. And again, I'm waiving your probation supervision fees. The most important one is that you go to Hope House and you complete that program.
Okay.
If you get kicked out, that's violating a special condition of your probation, which means I could revoke up to all 5 years of the probation. Okay? And I will set a behavioral incentive date of February 26th, 2028.
Okay.
That means if you get through 3 years of probation,
Yeah.
you finish Hope House, you've done your community service, you haven't gotten arrested again for doing anything like this, then probation can decide, you know what, we'll close this out.
Yeah.
They don't have to do that, but they might if you've been doing well.
Stay out of trouble.
Exactly. It is an incentive to stay out of trouble, take your meds, and just head in the direction that keeps you out of jail.
Okay.
Okay? Now, that's a little different than what the state recommended. I think the state's recommendation made a ton of sense. They just had more probation.
Yeah.
And I'm going to figure out pretty quickly if you have turned a corner and are staying on your medications and staying out of trouble. I don't need 8 years to know that. I need about a year, and then we'll deal with your probation accordingly.
Because I completed behavioral health court.
Good.
I was on medication, doing everything right. But when the program ended, it was no like long-term,
Right, and that's the struggle, because you're gonna get out of Hope House and we need to figure out how to, and maybe that's getting to North Carolina, where there are people who can
that's what I
support
plan
you.
on doing.
Yeah,
Because everybody know here is mostly just drug addicts, drug
yeah,
users.
and those are, they're not your friends.
Yeah, I talked to my mom about it yesterday. Yeah.
Yeah.
Okay.
Is there a probation issue we need to work through?
Actually, no, since he'll be going into Hope House.
Okay.
He won't have any reporting instructions. It's just as long as he understands, as long as he abides by their rules.
Yep.
He won't face a revocation.
Okay.
Judge, I
Do I call?
do we need to address his probation case that he has?
That's the one with Judge Edwards?
Yeah, the one that the warrant was submitted for.
Was the warrant predicated on one of these arrests?
The warrant was for the charges for 2172, and then the supervising officer added the other 3 cases.
Okay, got it. How much time remains on that case?
Well, that actually, because he only has 1 year, 6 months and 21 days, that could fall under the 2-year community time.
Yeah, why don't we do, well, but I did it a little differently. It was 18 months to serve. And so why don't we just revoke the 18 months credit for time served and close that one out? Okay. All right, and let's just get that case number in the record. That case number is?
21 SC 178056.
Okay, and Ms. Wood, you waive any due process notice rights to have us do that revocation?
Yes, Judge.
Excellent. Okay. Ms. Dilligard, anything else in connection with Mr. Haynes's many cases?
So we'll set it down for restitution.
Yeah, so the way that works, when one of the defense attorneys says, I want a restitution hearing, you will coordinate with Ms. Nelson, and you'll prove it up however you want to. It may be that there's a receipt from Publix, or Mr. Howe comes in and testifies, and it may be that you are able to produce some paperwork that when you share it with Ms. Wood, she says, we don't need to have a hearing now, I can see what this is. These dollar amounts are low enough, you may be able to sort something out. Every once in a while, someone comes in and says, it was a $10,000 dress that was stolen. And the defense like, yeah, that's got to be proven up. And then you do a little due diligence and say, you know what, never mind about restitution. These dollar amounts, I mean, it sounds like it's the Publix receipt, that kind of thing. So whenever you're ready to move forward, should you choose to, just let Ms. Nelson know and we'll do it. Okay? All right, I think that is it. So, one thing, Mr. Haynes, the folks at Hope House are asking that you do another TB test.
Okay.
For whatever reason, even though you just took, they want a more current one, because you're probably thinking, when do I go to Hope House?
Yeah.
I need to hear from the jail that all is good with the TB test, and then.
They just do my blood, okay.
Okay, but they're gonna do it one more time, and Ms. Wood will then let me know, and she'll fill out what's called a transport order so that the sheriff's team will take you to Hope House.
Okay.
And that'll be your new home, and you need to dive into that, okay?
Yes, I am, yeah.
All right.
Okay. Thank you.
I can get it. All right.
All right, folks, I think that is it. We've got a motion for new trial this afternoon. So Ms. Jackson, we're good for today. tomorrow is drug court. I guess we'll need you in the afternoon for our Zoom calendar. But otherwise, we're good.
Thank you. Have a great day, Yonner.
Thank you, ma'am. You too. And let me see if we have a different Zoom. We do. All right, so I can end this. Everyone have a super day.
You too, Judge.